Welcome to you all. Today, I am Rajan Jain, and today we will cover topic section 29A of IBC 2016, persons not eligible to be resolution applicant. The Insolvency and Bankruptcy Code 2016 offers a mode of resolution for distressed corporates. To address a major loophole, section 29A was added to the code by the IBC Amendment Act 2018, and owing to this provision, persons who by the misconduct contributed to defaults of the corporate debtor or are otherwise undesirable are prevented from gaining control of the corporate debtor. The provision protects creditors of the company by preventing unscrupulous persons from rewarding themselves at the expense of creditors and undermining the process laid down in the code. The introduction and application of Section 29A is reflective of a broad skepticism towards allowing promoters and directors to regain control of companies that went into financial distress under their watch. The Honorable Supreme Court in Arsenal Mittal India Private Limited was pleased to observe that the purpose of Section 29A of the IBC was with respect to the wider public interest as well as to encourage good corporate governance. A unique feature of the IBC that is absent from both UK and US insolvency and bankruptcy design is the condition prescribed by the IBC for proposed resolution applicants of insolvency resolution plans. Section 29A of the IBC contains a list of creditors that would qualify a potential bidder from submitting a resolution plan for the consideration of corporate debtors creditors. Honorable Supreme Court in Swiss Ribbons Private Limited held that the primary focus of the legislation is to ensure revival and continuation of the corporate debtor by protecting the corporate debtor from its own management and from a corporate debt by liquidation. With this background, we move towards PPT to cover further on this subject. So I'll just briefly introduce here as the scope and structure of IBCs. So what IBC is a transformational piece of legislation. It has brought about a paradigm shift in the existing insolvency laws as it moves from debtors in position to creditors in position. It instills a significantly better sense of credit discipline and has brought about a desired behavioral change in the attitude of both borrowers and creditors. The jurisprudence of the code has evolved in a manner that has made it predominantly clear the object of the code is resolution of the corporate debtor. Under the Constitution of India, bankruptcy and insolvency is entry 9 in List 3 concurrent list. This is both central and state governments can make laws relating to this subject. IBC code is divided into 5 parts and has 255 sections. So part 1 is preliminary, part 2 insolvency and liquidation of corporate debtors, part 3 insolvency resolution and bankruptcy for individuals and partnership firms, part 4 regulator of insolvency agencies and information litigation, and part 5 is miscellaneous. So IBC provides for a market-linked and time-bound resolution of stress assets. For cities facing insolvency, the code spells out the two processes, that insolvency resolution process, CIRP, and liquidation. When insolvency is triggered under IBC, all attempts are made to resolve the insolvency in time-bound manner. If the attempt fails, the company or the CD will be liquidated. So as already discussed, IBC has been designed to explore revival opportunities for all ailing corporate entity. Thus, it invites potential resolution applicants to come forward and submit resolution plans. Approach initially was all-inclusive and any persons could come as resolution applicant. However, this became a second chance for defaulting promoters who either directly or through related entities were able to buy back the companies at hugely discounted price. Therefore, need arose to restrict such defaulting promoters to come back to power and repeat the history. Section 29A, often quoted as a controversial provision of IBC, was thus enacted by way of amendment. Section 29A is a negatively prescribed list and enumerated persons who cannot be resolution applicant. Next, we'll go to what is the evolution of Section 29A. The IBC was introduced in the Lok Sabha on December 21, 2015. IBC code was thus referred to Joint Committee of Parliament on December 20, 2015 and is recommended by the committee on April 28, 2016. Code was then passed by Lok Sabha on May 5, 2016 and by Rajya Sabha on May 11, 2016 respectively. Subsequently received assent from the President and was notified in the Gazette on 28 May 2016 and became effective in December 2016. Section 29A has seen multiple amendments since by its insertion of the IBC Code Ordinance 2017. The ordinance was replaced by IBC Act 2018 on January 8, 2018 with effect from November 23, 2017. Subsequently, IBC Code Ordinance 2018 Act 2018 was promulgated on June 6, 2018, making certain other amendments to Section 29A. Okay, now we'll move into what are the insolvency stages and insolvency stage and application of Section 29A. Section 30. As per Section 30 of the IBC, a resolution applicant may submit a resolution plan along with an affidavit stating that he is eligible under Section 29A to the resolution professional prepared on the basis of information memorandum. Provided further that where a resolution applicant referred to in the first proviso is eligible under Clause C of Section 29A, resolution applicant shall be allowed by the Committee of Creditors such period not exceeding 30 days to make payment of overdues in accordance with the proviso to Clause C of Section 29A. Section 240A, it's an exemption, provides that provisions of Clause C and Clause H. Clause C is about NPA and Clause H is about guarantees of 29A shall not apply to the resolution applicant in respect of corporate insolvency resolution process or pre-packaging process of any micro, small and medium enterprises. MSME exemptions, when Section 29A was inserted, concerns were raised about whether there would be any non-promoter resolution applicant interested in all in the resolutions of MSME. Note that while Section 29A is not limited to promoter disqualification practice, since the majority of companies undergoing the CIRP would have a non-performing asset more than a year old, or promoters would have given a guarantee to the lenders, most promoters CD would end up disqualifying under Section 29AC and 29AH. Given the importance of MSMEs and recognizing the promoters of an MSCs are likely to be interested in acquiring it, the government restricted the applicability of Section 29A by way of Insolvency and Bankruptcy Amendment Ordinance 2018, later replaced by Insolvency and Bankruptcy Code Second Amendment Act 2018, which introduced the Section 240A of the IBC. Now we'll see at liquidation stage and applicability of Section 29A. In addition to influencing the insolvency resolution process, the ineligibilities under Section 29A also decides the person to whom the company's assets may be sold after liquidation order is passed by the NCLT. 2018 amendment to the IBC that inserted Section 29A in the IBC also amended Section 35 of the IBC, which entirely gives the liquidator the power to sell the corporate debtor's movable and immovable assets during liquidation. After the amendment, liquidator is prohibited from selling movable and immovable assets of the corporate debtor to any person who is not eligible to submit a resolution plan. This makes 29A applicable to purchasers of the company's assets during liquidation. So we see the chart here, which says IBC here means the creditors have an option whether to relinquish or not to relinquish their security interest. If the creditor decides to relinquish security interest under Section 52 in favor of liquidation asset, liquidator will to have two options: sell the entity as a going concern under Section 230 of the Companies Act, and sell the asset or sell the asset in piecemeal basis. If the liquidator opts to sell the asset as going concern under Section 230 of the Companies Act, Regulation 2B of IBBI, Liquidation Process Regulations 2006, provides that the person who is not eligible in the code to submit a resolution plan for insolvency resolution corporate debtor shall not be a party in any matter to such compromise arrangement. So the Supreme Court, while analyzing the interplay between liquidation and IBC, between liquidation under IBC and Section 230 of the Companies Act 2013, concludes the scheme under Section 230 of the Act being a mode of revival of the corporate debtor. Restrictions imposed under Section 35, subsection 1, clause F of the IBC shall be applicable. However, the Supreme Court observed that the scope of Section 230 of the Act is very wide. The restrictions imposed by Section 35, subsection 1, clause F shall only be applicable when the scheme is being submitted for a company which is in liquidation under IBC and not otherwise. Supreme Court held that while withdrawal under Section 12A pertains to a simpler withdrawal of a petition, however, scheme in essence a settled mechanism, once approved by NCLT under Section 230 of the Act, shall have the status of culmination of the process under the IBC. So what we are saying means once a scheme is approved under Section 230, then the process comes to an end and the corporate debtor gets a fresh slate. The same having a binding effect on corporate data, its creditors, members, liquidators, and successful resolution applicants. While deciding the challenge to regulation to be one of the liquidation regulations, Supreme Court noted that its introduction was only clarificatory in nature. Regulation 2B subsection 1 ensures that the disqualification and enumerated under Section 29A of the IBC are also made applicable to Section 230 of the Act, thereby bringing in alignment the legislative intent behind introducing Section 29A into the IBC. So this is a chart which gives a brief idea as it is applicable each stage. If it's relinquished and sold as a going concern under Section 230, then also Regulation 2B says you cannot sell the entity as a going concern to the existing corporates. If you're selling piecemeal also, Section 35(1) of the IBC provides the liquidator shall not sell the mobile and immobile property or actionable claims of the corporate debtor in liquidation to any person who is not eligible to a resolution plan. Simply, creditors decide to relinquish its security assets in favor of liquidation estate. Decide not to relinquish liquidation its security assets in favor of liquidation asset under Section 52. Regulation 37(8) of IBPI says the secured creditor shall not sell or transfer an asset which is subject to security interest to any person who is not eligible under the code to submit a resolution plan for insolvency resolution of the corporate debtor. Thus, in the whole process of the IBC, what we are saying means existing promoters and the directors of the corporates are kept out of the resolution process. Let's move to the constitutional validity of Section 29A. The constitutional validity of Section 29A was held in Swiss Ribbons Private Limited. Here the Supreme Court held in Swiss Ribbons that the primary focus of legislation is to ensure revival and continuation of corporate data by protecting the corporate data's assets from its own management and from a corporate debt by liquidation. Similarly, court also detailed that resolution applicants have no vested rights to be considered as such in the resolution process, and therefore Section 29A of the Code does not take away any vested rights. Further, it also stated that Section 35 subsection 1 of the Code, which states that the liquidator shall not sell the mobile, immobile property or actionable claims of the corporate debtor in liquidation to any person who is not eligible to be a resolution applicant, being the same legislative purpose which premade Section 29 of the Code, is constitutionally valid. Further, a legislative policy that a person unable to service his own debt beyond the prescribed grace period is unfit to be eligible to become a resolution applicant cannot be faulted. Neither can the period of 1 year be found fault with, as this policy matter decided by the RBI and which emerges from its master circular as during the period an NPA is classified as substandard. So we'll move to the next slide. Now, in the case of SR Steel India Limited, the Supreme Court has come out with certain clarifications as to what is the role of resolution professional, what's the role of committee of creditors. So, resolution professional duty is to ensure 29A compliance. Resolution professional needs to ensure the resolution plans submitted are complete in all respects before they are placed before the committee of creditors, who may or may not approve it. Resolution professional is required to give his or her prima facie opinion to the CoC confirming if any law, including Section 29A, or has not been contravened. Means resolution professional only can give an opinion, but he is not expected to give any judgment on the matter. So he'll form an opinion, and that opinion will place to the CoC, and CoC will take the ultimate final call. So this is the role of resolution professionals, which is restricted, which is what we say as per Supreme Court guidelines. Now let's come to what's the role of committee of creditors. Generally, what we say, the committee of creditors' wisdom is supreme, and whatever the decisions taken by CoC generally are not questioned. But here, what Supreme Court observed, the rejection of the resolution plan by the CoC, claiming the resolution plan violates the provisions of any law, including the grounds the resolution applicant is ineligible under Section 29A, is not final. It means whatever the CoC takes decision, that is not final, and that can be challenged. So the window is kept open for the resolution applicant. So the adjudicating authority acting quasi-judicially can determine whether the resolution plan violates the provision of any law, including Section 29A of the Code, after hearing the arguments of resolution applicant as well as the CoC. Subsequently, appeal can be preferred from the decision of National Company Law Tribunal to the Appellate Tribunal, that is National Company Law Tribunal. So when CoC takes a call that's not final, that's what Supreme Court says, and that can be taken up with the higher court if need arises. That is what conclusion does come from this. Next, lifting of the corporate veil and knowing the real persons. So now, actually, at the time of resolution applicant, if it is a corporate, then how is to be looked into, how the matter is to be looked into. The Supreme Court says you have to look into the real individuals, entities who are acting jointly or in concert, and who have set up such corporate vehicle for the purpose of submission of resolution plan. Means the persons who are acting on behalf, means who are real persons acting on behalf of the company. Those persons are to be ascertained by lifting of the corporate veil, and the real persons are to be identified to know whether Section 29A is attracted or not attracted. Next is disapproval resolution plan. Supreme Court also concludes that if a resolution plan does not receive the approval of CoC with the requisite 66% of voting share of financial credit, the resolution professional is required to invite a fresh resolution plan within the limits specified. When no resolution plan is available, an aggrieved resolution applicant can approach the NCLT for relief only after resolution plan has been evaluated by CoC after voting and not prior to that. So now what are the type of defaults and which attracts, and these defaults are, if attracted, then the resolution applicant cannot apply for rehabilitation of the company. First layer, when the person itself is ineligible. Second layer, when a connected person is ineligible. Third layer, being a related party of the connected person is ineligible. And last, when a person acting jointly or in concern with a person suffering from first layer, second layer, third layer ineligibility becomes eligible. So what are the clauses in the Section 29A which attracts for disqualification? So clause A, it says undischarged insolvent. If a person is undischarged insolvent, he cannot bid for resolution of the company. Next, clause B says if he is a willful defaulter under the RBI's Reserve Bank of India's recommendations provided under Banking Regulations Act 1949. Clause C says non-performing assets. So we'll go these clauses one by one. So what is undischarged insolvent? Insolvent is a stage where a person is unable to repay its dues. So undischarged insolvent is a type situation where a person has not been resolved of his insolvency, and that's why it's treated as undischarged insolvent. Next, what's a willful defaulter? Willful defaulter under RBI's Act. So RBI Act gives a lot of conditions for this willful defaulter. So who are the persons treated as a willful defaulter? So according to the RBI Master Circular, a willful defaulter is a borrower who does not meet his obligation even when he has the ability to pay so, or does not use for the funds for the specific purpose for which they were borrowed, or redistributes the funds neither for the purpose for which they were borrowed nor in other form of assets. It means the funds which are borrowed are not used for specific purpose for which they were granted. Or if he has resources to pay and he is not paying, then he will be treated as willful defaulter. If he is a willful defaulter, then he cannot bid for the resolution of a company. Now let's see what is the NPE criteria. Clause C of Section 29A debars a person or any person acting jointly or in concern with such person who at the time of resolution plan has an account classified as NPA, is a promoter of the corporate debtor, the accounts of which have been classified as NPA, is in the management of a corporate debtor, the accounts of which have been classified as NPA, or is in control of the corporate debtor, the accounts of which have been classified as NPA. Therefore, any company which has its accounts classified as NPA for at least 1 year will not be able to submit a resolution plan. However, the code provides for a carve out that such person shall be eligible to submit a resolution plan if such person makes payment of all overdues with interest thereon and charges related to non-performing asset accounts before submission of resolution plan. So if he is clearing of all the overdues, in that case, he is eligible for resolution of the corporate debtor. Provided further that nothing in this clause will apply to resolution applicant when such resolution applicant is a financial entity and is not a related party to a corporate debtor. Suppose a bank has converted some portion of its debt into equity, And to resolve the stress, in that case, the financial institutions cannot be treated as related party of that corporate debtor. So these are some excluded clauses. Next, we will move to the next clauses. What is clause D2F? So if any person is convicted of any offence punishable with imprisonment for 2 years or more under any act specified in the 12th schedule, or for 7 years or more under any law for the timing in force, or disqualification shall not apply to a person after the expiry period of 2 years from date of his release from imprisonment. So these are the conditions subject to which they can apply or they are not or cannot apply. So clause E says disqualified to act as a director under the Companies Act 2013, or is prohibited by SEBI from trading in securities or accessing the security market. So these are some explanations regarding this. So regarding directors, it says under Section 164 Companies Act, a director is disqualified if he turns out to be of unsound mind, he or her case is pending before the court on insolvency or unsoundness of mind, he has been sentenced for 6 months for imprisonment for an offence involving moral turpitude, an order has been passed by court or tribunal declaring him to be disqualified, he didn't pay his calls on shares, or he or she has been convicted of offences relating with related party under Section 188 of the Companies Act 2013, he or she is prohibited from acquiring din, then he is said to be disqualified to act as a director under the Companies Act 2013. Or he is prohibited by SEBI under Section 3 and 4 of Prohibition of Fraudulent Unfair Trade Practices, then he cannot submit a resolution plan. Next, Clause G talks about order for avoidance transactions has been made by adjudicating authority under this code. So what are these avoidance transactions? So these are, we'll see. So what it says is, according to Clause G of Section 29A, a promoter or person in the management of or control of a corporate data in which preferential transaction under Section 43, undervalue transaction under Section 45, extortionate credit transaction under Section 15 or Section 50 or fraudulent transaction under Section 49 has taken place, and the adjudicating authority has passed an order under the code. The provision is qualified to the extent it uses the term corporate data, and the adjudicating authority should have passed an order under the code itself. However, this clause shall not apply if a preferential, undervalued, extortionate credit transactions or fraudulent transaction has taken place prior to the acquisition of the corporate data by the resolution applicant pursuant to a resolution plan. Suppose a new resolution applicant has taken over and it has come to and these preferential transactions were related to earlier management, the new resolution applicant will not be responsible or he will not be treated as a related party in these cases. Next, clause H says guarantor executing guarantee in favor of the applicant creditor. A person shall not be eligible to submit a resolution plan if such person or either person acting jointly or in concern with such person has executed a guarantee in favor of creditor in respect of a corporate debtor against whom application for insolvency resolution made by such creditor has been admitted under this code, and such guarantee has been invoked by the creditor and remains unpaid in full or part. The main part is here, the guarantee is invoked and it remains unpaid in full or part, then he'll be disqualified under clause H. Next, any connected persons not eligible under clauses A to I will also be disqualified from applying for resolution plan of the corporate. So there are 3 clauses of connected person. Clause 1 says control and management of resolution applicant. If any person who is a promoter or in the management or control of the resolution applicant, or clause 2 says any person who shall be the promoter or in management or control of the business of the corporate debtor during the implementation of resolution plan. Clause 3 says holding company, subsidiary company, associate company, or related party of a person referred to in clause 1 and 2. So if these clauses are satisfied, then it will be treated as a connected person. If it is a connected person, he is disqualified from submitting a resolution plan. So these are some brief clauses. Now we'll go into what are the other judicial pronouncements which have come in. So in the case of Sandeep Kumar Bajaj and others, Section 29 says Section 29A or Section 31 would not provide a shield against the operation of Section 14, subsection 3, subsection B of the code. That is, the moratorium will you can proceed against the guarantors, and Section 14, the moratorium will not interfere in the process. that it implies. In the case of wing associate, this is a case where ordinance, since the application was admitted prior to the promulgation of ordinance bringing Section 29A into force, the resolution plan would be eligible for due adjudication. Means prior to bringing Section 29A, any plan was submitted, then that plan is means it is accepted by the adjudicating authority. So now next, State Bank of India versus Anuj Bajpayee, Enclave order dated 18/11/2019. If the Enclave held that if it comes to the notice of the liquidator that a secured creditor intend to sell the assets to a person who is ineligible, in terms of Section 29A, it is always open to reject the application under Section 52, read with Section 52 and 3 of the Code. That is, if a person, that is, he cannot relinquish that security asset, means he has to relinquish the security asset in favor of the liquidator. He cannot come out of the liquidation process. Next, these are other case laws. K. Periswamy versus others. The certificate issued by the Ministry of MSME raises no objection to the fact that CD is an MSME. So as we have already seen under Section 240A, the MSMEs are exempt from are exempt from the disqualifications. They can submit a resolution plan if their clause C and H is attracted. So this is a case which deals with that. Next, Jindal Steel and Power Limited. Promoter, if eligible under Section 29A, cannot make an application for compromise and arrangement for taking back the immobile and movable properties of actual claims of the CD. That is, he says, if an eligibility is attracted, he cannot, if eligibility is attracted, he cannot submit the resolution plan. He cannot submit a resolution plan even under a compromise arrangements under Section 230 of the Companies Act. Next, the intention, in case of Shravana Gold Holdings Limited, the intention of legislature shows that the promoter of MSE should be encouraged to pay back the amount with the satisfaction of CSE to regain control of the CD and entrepreneurship by filing a resolution plan which is viable. So overall, what I'm going to sum up is Section 29A is disqualifying the existing promoters and directors of the company from submitting a resolution plan for the company. So it is because of their actions under their watch the company has moved into a stressful state. So the intention is very clear that at the expense of the creditor, these existing promoters cannot be rich. So they have to leave the company, and the existing creditors will sell the company to the new promoters and new management. So to strengthen the corporate governance of the country, Section 29A will play a very vital role. So Section 29A, as Supreme Court has already pointed out, we have to, the main intention is resolution and to protect the corporate data from its own management also, and from the liquidation process also. So now what we are saying, that means except for MSME borrowers under Section 240A, they are allowed to submit provided they attract only these two, clause C and clause H of the disqualification. So next is the other judicial pronouncements, but I'm showing a chart as what is a connected person. So promoter of a RA, person who is management and control of the RA, holding and subsidiary and associate company of related party, promoter of CD during the time of implementation of resolution plan, person who shall be in management for control of CD during the time of implementation of resolution plan. So these are the chart which shows who are treated as connected parties, and resolution applicants, the relatives, the holding, the subsidiary, the associate parties, who are in the management control of the RA, or who are at the time of implementation of the resolution plan, or who shall be in the control of the CD during the time of implementation of the RP. So these all people will be treated as connected persons. So with this, I will wind up now. Thank you very much.